we are required to elect an acting chairperson. So before we proceed, I will do a roll call to determine whether we're correct and whether members are all on the platform. So I will call the names of members as on to verify their presence. Mr. Mumbayani? Mr. Muyani is on the platform. I'll proceed to Ms. Muatse.
Thank you very much, Andre, and good morning, colleagues. I'm present.
Mr.
Sorry,
Manamatia.
Andre.
Mr. Muyani.
Andre, I'm just getting into a lift, but I am here. It's Dean.
Thank you very much. I'm present.
Thanks, Mr. Malamatia and Mr. Muyani, both present. Ms. Mutahung.
Good morning, Andre. I'm present.
Mr. Thring.
Good morning,
is on the platform.
Good morning, present. Thank you.
Mr. Mulder.
Good morning, Andre. I'm present. I haven't seen you a long time. I see you went grey since I've seen you last time. Andre, I just want to report that I have got a doctor's appointment approximately at 10:30. If I could be excused, please.
Noted, Mr. Mulder. Prince Burns Namashe.
Molo Stalo, Namalungu. My voice is hoarse. I had a flu over the weekend.
No problem, Mr. Prince Burns Namashe. Mr. Cuthbert.
Morning, Andre.
Mr. McPherson has indicated he's present. He may still be in the lift. Just before we start proceedings, on behalf of the Secretariat, I would like to express our sincere condolences to Mrs. Hermans and her family for the passing of her son over the weekend. Our thoughts and prayers are with her and her family during this difficult time. Now, in order to elect an acting chairperson in terms of Rule 159, I'll call for nominations for the position of acting chairperson in the absence of Mrs. Hermans until she returns. Can I have a nomination for the position of acting chairperson? Ms. Mutahung.
Thanks, Chair. I nominate the name of Honorable Mbuyani to be our acting chair.
Thank you. Second, Ms. Muatse.
Thank you very much, Andre. I second the nomination.
Thank you. We have a nomination and a second for the position of acting chair. Are there any other nominations? There being no other nominations, I declare Mr. Mbiani duly elected as acting chairperson until the chairperson return, and I'll request Mr. Mbiani to take the chair. Thank you.
Thank you very much, Andre. Good morning, colleagues. Sending condolences as well on behalf of the acting chair to the chair of the committee. We are saying condolences to her and the entire family during these trying times. Colleagues and committee, you will pardon me, I'm in transit to Cape Town, but I will try to execute the task that you have just nominated me to do. And we will be quickly dealing with this matter so that we are not delaying. Even Akbar Melda will be covered by the after half-10 meeting. So today, colleagues, we will be dealing with the briefing by the DTIC on the status of the implementation. Can we get the agenda flighted, please? Yes, I think we have dealt with all these matters of apologies and so forth. We are now at a briefing by the DTIC on the status of the implementation of the following legislations: the Intellectual Property Laws Amendment Act, National Credit Amendment Act, Legal Metrology Act, Protection of Investment Act, and briefing by the DTIC on the status of the review process with regard to Consumer Protection Act and the National Gambling Act. So I don't know who's from the department, but I think there's the Deputy Minister, Honorable Machole, will give it to you so that we introduce the presentation and also the administration that they're supposed to present. Thank you very much.
Chair, before we hand over to the Deputy Minister, can we just have a move and a second for the adoption of the agenda?
On the agenda?
Yeah.
Oh, okay. I thought we dealt with all this thing. Because I see the agenda is not here. Can we have proposal and a seconder for the adoption? Comrade
Mr. Malematia.
Honorable.
Thank you very much.
Yes,
Thank you,
Mr.
Chair. I
Malematia.
propose we adopt the agenda.
Okay. There's a proposal that we adopt the agenda by Honorable Malematia. Any seconder? I don't see any hand.
Chair, Ms. Mutahung, Chair.
Ms. Mutahu.
Thanks, Chair. I second the adoption of the agenda.
Thank you very much. The agenda has been duly adopted. As we've outlined here to say, we will be dealing with the briefing by the DTIC on the status of the review process with regard to the Consumer Protection Act and the National Gambling. And also some of the legislations that we have. I don't know who's presenting Secretariat. Will you assist us? Is the DM in connected?
Chair.
Over to you,
Chair,
Chair.
the Deputy Minister is on the platform, Chair.
Okay. Deputy Minister, Honorable Majola, you can take it. And the presentation. Thank you.
Thank you. Thank you very much, Acting Chairperson, Honorable Mbuyani. And good morning to the honorable members of the committee. We will be presenting to you in two parts. Firstly, the progress with regard to the implementation of legislation, and the second part will deal with the review of legislation. Honorable Chair, can I take this opportunity to also join you on behalf of our department to convey our condolences to the Chairperson of the Portfolio Committee, Ms. Hemmens. And let us say that our thoughts and prayers are with her during this time and her family. So we have the DTIC team here, led by the Acting Director General, Shabir Khan. We also have representatives from our different entities who deal with the different pieces of legislation that we'll be presenting to you today. So without wasting time, Chair, because we have a fairly lengthy presentation, I would like to hand over to the Acting Director General to firstly introduce the team from the DTIC and our different entities who are present today. And then with your permission, I'll ask him to lead us in the presentation. I know that the different officials from the department will deal with different parts of the legislation that we'll be presenting. So the Acting Director General will take us through that. And so with your permission, Chair, can please hand over to the Acting Director General. Thank you, Chair.
Thank you very much, Acting DG. You can take us through the presentation. Thank you. Over to you.
Thank you, Deputy Minister Machola. Good morning, Honorable Chairperson, members of the Portfolio Committee, staff of Parliament, and the colleagues on the platform. Chair, I'm going to quite quickly introduce the delegation from the department and its entities. Whilst I'm doing that, I'll also kindly request Ms. Solofelo Mushi to load the presentation on the screen. And I will also then introduce the presenters who will take us through the various aspects of the presentation. In the delegation this morning, we do have Dr. Evelyn Masocha from our Consumer and Regulatory branch, as well as Dr. Zandile Brown. We also do have Ms. Nikki Kruger from our trade unit. We also do have Ms. Elizabeth van Rienen, Dr. Shenge Dimana, Dr. Anna-Marie Lotter. We also do have colleagues from the National Consumer Commission, led by the Company Secretary, Mr. Joseph Silolo, the Head of Legal Services, Mr. Jabulani Umbeje, and the Legal Advisor, Mr. Imran Mahoro. From the National Credit Regulator, we are joined by the Legal Senior Advisor, Ms. Ntupango Maholejo. From the NRCS, we do have the Acting CEO, Ms. Rebecca Ramcharan, the Acting COO, Mr. Duncan Mutengwe, the Head of Risk and Strategy, Mr. Edward Matembe, and the Acting GM for Legal Metrology, Mr. Yako Manevek. From CIPC, we have Ms. Namonde Mamela and Dr. Tandanani Suelia. And lastly, from the National Gambling Board, we have the Chief Compliance Officer, Mr. Nkutse Mashemate. Chair, Sulu, if you can perhaps take us to the next slide of the presentation. Chairperson and members of the Portfolio Committee, the different presenters that will cover the various aspects of the slides. Dr. Evelyn Masocha, the DDG for Consumer and Corporate Regulations, will cover the Intellectual Property Laws Amendment Act, the National Gambling Act, the Consumer Protection Act, as well as the National Credit Amendment Act. Ms. Nikki Kruger, who is the Chief Director in our trade unit, will cover or provide a progress update on the protection of the Investment Act. And lastly, Dr. Shenge Dimane, who is the Chief Director in Industrial Competitiveness and Growth Branch. He will provide an update on the Legal Metrology Act. Chairperson, with your permission, I will then hand over to Dr. Evelyn Masocha, who will then take us to the first part of the presentation. Thank you so much.
Thank you very much. DDG, can you continue with the presentation?
Thank you, Chair. Thank you to the Acting DG, to the Deputy Minister, to the parliamentary staff, to all my colleagues in the department, including Legal Services, the Chief Director, Ms. Ntokozo Kamba and her team, and all the entities who are here with us today, and everyone in the platform, good morning. Thank you for this opportunity for the department to present on the progress update on different sets of legislation from the review and to the implementation. So I will
DG, I think the DDG is fading. I don't know what's the challenge. Maybe it's a network.
Chair, can you hear me?
Yes, we can hear you now.
Okay.
I think we must just get the right spot for you so that you can be able to hear you.
Oh, all right, Chair. There's a background sound, Chair. I'm not sure if someone's mic is on in the platform. I'm hearing a background sound. If it's possible that everyone can also mute their mics. All right, thank you. So I will be presenting on the status of implementing the Intellectual Property Laws Amendment Act, the National Credit Amendment Act, and then the review of the Consumer Protection Act and the National Gambling Act. My colleagues will cover the other areas as indicated by the acting DG. And Chair, in the presentation, given the time constraints, it's quite a detailed presentation on the legislation. However, what I will then do is to speak at on the high level about where the legislation is and cover the update, and not so much on the provisions that are in the legislation. So that because I'm going to cover 4 areas, so it might be very detailed and it might require more time. So I'm going to try to be as brief as possible, but covering the gist of what this presentation is about. On this slide, Chair, on the National Gambling Act, is just to provide an overview of the legislative processes and the status of where we have been on the legislative framework of the national gambling legislation. It started in 1995 with the WIA Commission that recommended the strict regulation of gambling. And then we had the Gambling Act, National Gambling Act of 1996 that was introduced, and it also established the National Gambling Board. Then we had the Act again reviewed for 2004, where we then had the National Gambling Policy Council that was established in that Act. The Policy Council is a very important coordination platform between provinces and national government on the gambling mandate because of the concurrent jurisdiction of gambling. And then we had the National Gambling Amendment Act in 2008. This is a very important piece of legislation that was passed into law, dealing with remote gambling and from an interactive gambling perspective. This legislation currently has not come into effect. It was never promulgated, but it is in the statute books. Then we had the review of the whole gambling environment by doing a Gambling Review Commission report in 2010 that made several policy recommendations on gambling in the country. At the time, one of the concerns was about the proliferation of gambling and the direction government needed to take to look at gambling as one of the sectors in the economy, and plus the balancing of the social harms of gambling in society, plus ensuring there's a regulatory framework that is sound and in line with best practices. So that commission informed the policy processes that followed after that, where we had the policy on national gambling, and we also had the National Gambling Amendment Bill that was introduced into Parliament in 2018. So that was the subsequent processes. It was introduced. Following that, it went through the parliamentary process until where we are now, where it is in the mediation process. So when I go into the other slides, I'm not going to go into much detail because I've covered most of the background around that slide. So this slide is very important because it talks to the role the WIA Commission played in setting the key principles around gambling in the country. So it informed the policy direction, and those principles remain critical even to date. One of the main emphasis of this commission's recommendations was around the protection of society from the overstimulation of gambling through the limitation of gambling opportunities. Also, in terms of ensuring that there's a strict control and supervision of the industry through providing a regulatory framework that protects players and ensuring that there's integrity and fairness of the industry. And in terms of norms and standards, it was important that there is uniformity and harmonization of policy and legislation at all levels of government, and there's proper coordination. And very importantly for the economy, the issue of the generation of revenue and taxes for provincial governments and for good causes. And the National Gambling Mandate is also seen as important in terms of driving part of the economy and ensuring that the historically disadvantaged benefited also from this important piece of legislation. Overall, the intention is to promote economic growth, development, and employment. So Now one moves to the National Gambling Amendment Bill as the most recent work that was undertaken by the Department and Parliament on the national gambling legislation. To just give a background here, the bill that was introduced was comprehensive. It was comprehensive in the sense that it addressed many issues beyond just looking at the governance administrative issues. One of the areas that we're going to look at was how to the oversight of the horse racing industry, as an example. It had many other provisions, but however, because of the timing when it was introduced and the fact that Parliament was about to rise for the next administration, it was reduced in terms of focusing on the core governance related issues. I will take the committee through those issues briefly, just to ensure that there's a sense of what the bill aimed to achieve in broad terms. So in terms of the purpose of the bill, one of the main critical areas of focus was the reconfiguration or the restructuring of the National Gambling Board to a national gambling regulator led by a CEO. As many may be aware, the board of the National Gambling Board was dissolved in 2014 due to governance and other related issues that led to that decision. And then the entity went into administration, overseen by the leader there as an administrator. And so because of the importance of ensuring that the situation is amended or corrected, there was a need to ensure that this issue is addressed in terms of corporate governance. So it's one of the key provisions that were developed in the bill. Another area was the provision of the automatic forfeiture of unlawful winnings to the National Gambling Regulator. Currently, there's a procedure for the forfeiture of unlawful winnings that is quite a bit cumbersome, and it requires procedures like involving the courts. And this was meant to simplify the processes and also to ensure that the winnings are not forfeited to the government coffers, but to the National Gambling Regulator to assist with their revenue generation for combating issues of illegal gambling and other related issues. And then the key one was that with the National Gambling Policy Council, issues of the quorum have become very critical because of the issue of harmonization, ensuring that there's national norms and standards in the country. It's important that the national and provinces are in alignment when it comes to critical gambling related issues. So the quorum of the National Gambling Policy Council is a very critical measure in terms of ensuring that critical decisions are taken. What has happened over the years has been that a quorum has been an issue that has affected key policy decisions, harmonization across the national and provincial gambling boards. So this has led to challenges of certain decisions being delayed, and over long periods of time, there will not be a quorum. Efforts will be taken to ensure that in meetings we have the right numbers of MECs, but then at the last minute, meetings will either be postponed, cancelled, or there will not be a quorum. Then issues will only be noted. And this has affected decisions related to the national gambling mandate. So the bill sought to address this issue by proposing a solution to address that. And another area was the extension of the National Central Electronic Monitoring System to other modes of gambling. Currently, it only focuses on the limited payment machines sector, and it does not talk to other modes of gambling like the casinos and so on. So the intention was to ensure that it's broadened to improve the information collection in terms of gambling statistics, gambling information, ensuring that there is more oversight over this and working collaborations with the provinces to ensure that there's the information is sound, and then there's more in terms of the profiling of the gambling industry in the country. There's more value add to the process. So that's one of the key recommendations that were provided in this amendment bill. And also to enhance the powers of the National Inspectorate to curb illegal gambling activities. The Inspectorate in gambling requires some attention. And the provisions in the bill were to ensure that there's more capacity provided for Inspectorate by involving the National Gambling Board to work very closely with the provinces, but also giving the board more powers to be able to take certain actions whenever there is a need. So this is one of the areas that was is in the bill for further consideration. In the slide, it's mainly processes. Just to talk to the timelines. The processes started in 2015 when there was a national gambling policy that was published for broader consultation. Other processes culminated, including the cabinet processes, the public participation, where the bill was made when it was finalized for publication to the public, and the different processes that were undertaken. So this is more of a procedure kind of a slide, similar to the next slide, where focus was on when it was introduced in Parliament, the briefings that were undertaken by the department, the public hearings that happened in 2018, and the whole process, even including when it was adopted by the National Assembly and then taken to the National Council of Provinces in 2019. And in 2021, it was then referred to mediation because of challenges with some of the voting with the provinces. So the bill was revived in the 6th administration, and from its revival, there were further consultations in provinces. It was in the Select Committee, the Select Committee on Trade and Industry, Economic Development, Small Business Development, Tourism, Employment and Labor. It was there after that duration. And in 2021, December, following the report transferred to the NCOP, it was then referred to mediation. I'm going to then talk just briefly on concerns raised about the bill. I will pick the ones that were the most critical ones, and then move to the way forward and the update, the main update of the bill. So in terms of the establishment of the National Gambling Regulator, this was a very contentious issue, especially for many provinces who are of the view that there is a need to have a board where the CEO can account to the board. But to have a regulator who's a CEO is giving too many powers to an individual. And there is a need for a board. So there was that conflict around board versus individual CEO. From the department side, our recommendation was that based on the trends and developments with boards and governance issues and some of the challenges that we have experienced with the lessons and learned over time, we were of the view that even based on the entity rationalization research that was done, that a board that is led by, or an entity led by a regulator, a commissioner or CEO is effective. And we have examples of such entities in the department. So that's where the point was coming from as well. So we were not of the view that the board will, the regulator will fail based on the fact that it's only a CEO, because we have commissioners running entities without boards, with a CEO doing the same. But it was a contentious issue. The next one is the National Central Electronic Monitoring System. On this one, there were concerns raised that there is already capacity in provinces. Operators are working with provinces. Provinces also, some provinces indicated they also wanted to have their own NSEMs. Currently, it's a national capacity, national mandate for the NGB provided in the Act, focusing on the limited payout machines. So we thought because it's already a mandate of the NGB, it can be extended to ensure they have more capacity in terms of regulating, monitoring systems, and having an oversight over gambling-related information, being able to see if there are challenges. And also, we thought it will also assist with the profiling of the country in terms of being a destination of credible gambling practices, gambling information, and so on. But it is one of the contentious issues that was not supported by some of the provinces. And then now to come to the National Gambling Policy Council, this one is one of the most contentious ones. The provision in the bill proposed that MECs, when a decision is taken, 5 MECs are required plus the minister to make a decision. That has proven to be a problem because there will not be enough MECs in the meeting. We will follow up, send out invitations, last minute, there are cancellations, or they don't come. So because of that, we realized this is affecting the norms and standards. So the implication of this was bigger, even though one can say, but it's just a meeting. Why don't we do round robins and so on? Even the round robin option was explored. It has not worked. We will not get feedback and so on. So many options have not worked. The only thing that we thought might have, which was a bit stronger, might have an impact was to ensure that if in the first meeting there's no quorum, in the second meeting, the number of MECs that are there can make a decision, and the decision then will have implications for other provinces. So this was highly contentious. It was opposed. There were concerns about it to say, but no, this cannot be the case. So this is where we are on this one of the areas that was not supported by the provinces. Likewise with the National Inspectorate, to say that as it is functional right now, it's sufficient. The National Gambling Board does not have to get too involved, as we were trying to empower and to support. It was also contested, this National Inspectorate issue. So in terms of the voting, the final mandates, two provinces abstained from voting, Eastern Cape and the KZN. And then there were provinces that voted against the bill. There were 4, and that is the Free State, Gauteng, Northwest, and Western Cape. Those who voted in favor were the Northern Cape, Northwest, and Mpumalanga. And so overall, the bill was not supported in general. It got some support, but not sufficient enough to be able to be supported or passed or adopted by the NCOP. So in terms of where we are now, the bill currently is in the mediation. It was referred on the 14th of December 2021. There was a meeting scheduled in June. However, that meeting was cancelled. So the department awaits the next processes based on the scheduling of the mediation committee, and also based on how the parliamentary processes unfold. Then we will be participating in that order. So I move then to the Consumer Protection Act of 2008. This legislation came into effect in 2011, in March 2011. It was replacing the laws that were repealed. They include the Unfair Business Practices Act, the Sale and Service Matters Act, the Trade Practices Act of 1976. The legal framework at the time was very complicated. Consumers were burdened by unfair practices. There was no transparency. Policies were not clear. There was no proper redress. And so generally, the market was constrained. Access to information was not clear in terms of your rights, what happens with your purchases, and when there are challenges and so on. And there was a need to align to best practices globally and ensuring that consumer rights are prioritized and there's consumer protection. So the CPA seeks to protect consumers in their day-to-day dealings with retailers, suppliers, and other businesses. So the Act provides comprehensive consumer redress for consumers and established the National Consumer Commission. On this slide, I won't go into the details of it. It's just to indicate that the Act is so comprehensive as a law of general application. It promotes an economic environment that supports and strengthens a culture of consumer rights and responsibilities, business innovation, and enhanced performance. It promotes a fair, accessible, and sustainable marketplace for consumer products and services. It addresses issues of marketing of products, how consumers must deal with products that are not properly dealt with in terms of safety and defects. It prohibits certain unfair marketing and business practices. It also improves access to quality information that is necessary for consumers to make informed decisions, and also issues of safety and ensuring that they are protected from hazards. It provides for associations and other platforms that can be used by consumers for redress, and also ensuring that consumers participate in decision-making processes. So it provides for several rights for consumers. So in terms of our role, since it has come into effect, it has been several years. We normally review legislation after 5 years to ensure that any implementation challenges or policy issues are addressed and there's a review of policy. So we have conducted a regulatory impact assessment that was finalized in 2021 as part of kickstarting that process as a department to look at where are the constraints since implementation. Some of the issues that we included was informed by issues raised by the public, the engagements we've had, and feedback mechanisms that we received from time to time. So we addressed the following key areas. In the next slides, it's more details, but I'm going to focus on this one also in the interest of time. And bearing in mind that this is a process, the issues are not cast in stone. We are still going to look at different policy options. We're still going to engage with stakeholders, experts to check where are the main areas of consideration. So this is just to indicate that this is what we have done so far, and we are still looking into the issues to see what are the best options for the recommendations for policy. So one of the areas is the hierarchy of consumer complaints in the Consumer Protection Act. This has been an area of confusion for many consumers in terms of where is the first port of call when you make a consumer complaint, and which platforms can they access, whether it's the provincial offices, whether it's the NCC or the consumer courts. So there has been that. The Act does provide for this. However, we've noticed that we've been receiving many complaints about where do I start, who can help me, I don't get enough support, what happens if my matter is, it has not been dealt with over time, what happens if it cannot be dealt with further, and so on. So it's one area that we looked at. The other area was the mandate of the NCC in terms of consumer complaints handling, in terms of the extent of their involvement, where they fit in the hierarchy of complaints, or policy options of improving how complaints can be dealt with from a regulator's perspective. And then we looked at the impact of the misalignment of provincial consumer laws with the Consumer Protection Act and the general failure in the exercise of cooperative concurrent jurisdiction, because this is an area of concurrency as well between provinces and national. We looked at how best can provinces and national work together to ensure that consumers get the best protection and support and their rights are exercised. We also looked at the alternative dispute resolution measures available and how to effectively utilize them and the different ombud schemes that can be improved. And issues around warranty provisions, how to improve areas of warranty to strengthen those provisions. Then the issues of product recall, as you are aware of, several times you'll hear that there are products that are being recalled from shelves. What are the procedures? Is the Act clear on those? Where are the loopholes? And also on the issues of the genetically modified organisms. There's a lot of work here to be done with other entities and other regulators who are also addressing the same mandate. We're looking at how best do we then as a department participate in this and ensuring that the policy gaps that may be out there, we take them into cognizance. We also looked at issues of illicit goods from the CPA point of view. Do we have sufficient provisions? Should we include more provisions? What are the options? What are the recommendations? And also there has been a call for an ombudsman on the franchise industry. So we are looking at the possibility of an ombud around the franchise industry. So the research was also assisting in that regard. Many other issues can also be brought forward. The intention is to ensure that we take this work forward for the Consumer Protection Act. So I'm going to skip most of this. These are just slides that talk to the detail of the RIA, the regulatory study itself. So in terms of the review, we are looking at starting that policy process. The other work we are looking into is the industry codes that have been approved by the Minister for the motor industry and the consumer goods codes, and they are being reviewed also for further amendments. And we have received advice from some experts who are of the view that the Act as it stands should not be amended now. They are of the view that there's a need to implement it further before it's amended. So there's also that view that even though it's been more than 5 years, we can review the legislation, but there are those who are of the view, given the status of the law, we don't have to review it now. I mean, to amend, it still needs to be further implemented. And then on the timeshare legislation or timeshare work, there was an investigation that was done by the NCC, I think between 2018-19, if I'm not mistaken, they did that. There was that report and recommendations. We have since been working with them to look at possible regulations around the time-sharing legislation. However, just to add, we, given the legislation that deals with timeshare and some of the implications, we've been looking at where best can this legislation be in terms of the relevant other department. So the department currently is exploring migrating this law to the relevant department that deals with issues related to tourism or issues of timeshare as part of their core mandate. So it's one of the areas that we thought we can also highlight as work that we are undertaking. But that work, the NCC has found a way around it in terms of addressing some of the complaints that comes with the timeshare industry-related issues and so on. Now I'm moving to the Intellectual Property Laws Amendment Act of 2013. So in terms of the background to this legislation, the initial bill was introduced to the National Assembly in 2010. It undertook the parliamentary processes, and then it was passed by both houses and sent to the president in December of 2011. And then it was returned to the National Assembly by the president due to reservation about its constitutionality. One of the issues was about the consultation with the National House of Traditional Leaders that needed to be addressed. And then subsequently, it was passed into law, and it was passed by both houses in November of 2013, and it became an act of law in December 2013. So the department then was also trying to finalize the regulations, the DTIC. However, at the same time, the Minister of Science and Technology at the time introduced the Protection, Promotion, Development and Management of Indigenous Knowledge System bill to the National Assembly. And because of this process, the legislation are similar. The one for the DSI is broader in terms of issues of indigenous knowledge, traditional knowledge, and the focus of the one by the intellectual property law was more on intellectual property. So the processes had to be put on hold to address the alignment between the two departments. Just as an update, in 2017, their portfolio committee also called the department and the DSI to talk to the alignment between the two laws, and there were areas identified as areas of synergy. We came to the portfolio committee in 2020 March to also present with the Department of Science and Innovation on the alignment between the two laws and how the implementation was going to take place. So just as a brief background, I'm not going to go into too much detail on the gist or the content of the legislation. Indigenous knowledge is critical in the economic development and development of the cultural industry in South Africa. This law aims to recognize and protect certain manifestations of indigenous knowledge. We all know that our country has a rich heritage of culture that impacts on communities and our society. And the indigenous knowledge systems, they deal with research, development, promotion, education, and strengthening of the regime of indigenous knowledge. The law as it stands amends 4 existing IP laws. They include the Copyright Act, Performance Protection Act, Trademarks Act, Designs Act, and they are also amended in the certain forms to address the traditional knowledge protection. The law currently is not in force. It was never promulgated. There are no regulations concerning it. And one of the areas that we've identified with our regulator, the CIPC, is that we will contribute in this work, working in close collaboration with the Department of Science and Innovation. We will focus on the IP registration. And the regulator is available for this work when it comes to the registration of IP, when it comes to indigenous knowledge. And but we also acknowledge that the the law by the Department of Science and Innovation is broad enough, a sui generis law, which has got more options in terms of traditional knowledge beyond IP. And we support that process. And the institutions that we had in the Intellectual Laws Amendment Act, they have some of them, they will be addressed by the other department because of the similarities. And some of the ones that we had were seen to be problematic in terms of their practical implications. For example, the National Trust and how the National Trust coincides with communities. And in terms of other issues, there are experts who are of the view that this law needs to be repealed because of the soundness of some of its legal context. For example, issues around originality, issues around certain definitions. So there has been contestations around that in terms of how is it going to be implemented when it's not clear in terms of its implications on different aspects, like, for example, in the copyright area. So we as the department then sought a legal opinion in 2020, looking at the different areas of the laws and where are the challenges and the gaps. And they did indicate several issues of concern. For example, how this law will benefit communities directly. How do they deal with originality issues in an area that has been there over centuries? So they identified conceptual legal context issues that are of concern. So it's an area that we're still working on as a department. We just thought we should share this in terms of what we have done so far. So there was that legal opinion. We are still in the process of consulting with our minister further on what is the best approach. But then with our regulator, we contributed to the draft regulations in 2021 by the Department of Science and Innovation. We are in consultation with them in terms of how best do we work together to ensure that they can refer IP registration related issues to us, but we still need to get into the hurdle of how do we develop the appropriate regulations for this indigenous knowledge from the IPLA, from this legislation side. How do we do that? Because we still need to do some regulations. There are experts who are of the view we cannot just do regulations. We need to correct the act first. So there are implications and some areas we still need to iron out. But the area we've carved out for the department and CIPC is around indigenous knowledge registration. The form of it is something that we still need to review. But the feedback to the committee and members, honorable members, is that we are working on this. We are still engaging with the minister. We are still engaging with the Department of Science and Innovation. We are participating in their processes. We commented on their draft regulations. And we can also be allowed maybe later on to come back with a proper feedback of how far we are, because we are still in those consultations. They are still working on their side. As far as I recall, they're still finalizing regulations. I'm subject to correction because I was also trying to consult with them now to see how best do we still align, but we can come back later with more detailed information of where we are with them, even with the decision of the minister around the context of the law. The area that was highlighted by some experts was that just repeal the legislation, but that decision we have not reached that decision yet. So it's something that we can come back with more clarity about in the near future. So the CIPC is the entity that is responsible, is the entity that we will work closely with in this area of work. But overall, the law is not in place, it's not in effect. There's still work we are undertaking, there's still consultations underway, but we work very closely with the Department of Science and Innovation on this work. The National Credit Amendment Act of 2019. So this legislation was passed into law in 2019 by the President. We did come to the Portfolio Committee to present on the possible action plan of implementation. The initial plan was to have implementation in 2021, beginning of 2021, to start with the implementation. This law provides for debt intervention. It's a form of debt review process. It introduces procedures for the National Credit Regulator and the National Consumer Tribunal on how to rearrange debts of over-indebted vulnerable consumers who earn a particular threshold of income, 7,500 as a maximum, with unsecured debt of 50,000 or less. It was intended to address the gap in the market where consumers are not able to fit in the debt review process and other insolvency-related measures that are available to more sophisticated consumers who can access certain resources and information. And it involves debt rearrangements. It has procedures of how to suspend a debt, how to extinguish a debt, the role of the courts, the role of the tribunal, and it's a procedure of how to rearrange debt overall. And it also provides for offenses and criminalizing certain behaviors that are currently affecting consumers who are highly indebted and are not protected in the market. So as a department, since it was passed into law, what happened in the very same year, we started consulting with key stakeholders. We consulted with the banks, the retail sector through their federation. We consulted our entities, the NCR and the National Consumer Tribunal, because we were concerned about the implementation of the Act in terms of its implication, given the feedback we've received from the public, from the experts, and also from the industry. Then we undertook to come up with a blended and cost-effective approach to the implementation of the Act. So that process started of engagements. It continued in September of 2020. It was affected by the pandemic because of the reprioritization. And the relevant stakeholders were then requested to submit their proposals of how best to proceed with the legislation and implementation of it from infrastructure, hurdles in the Act. And what came up was that there are challenges that industry raised that needed to be taken into consideration. And they proposed some amendments before implementation. And we then had to consider those issues further. And so I'm just going to move quickly on some of the slides. So what we then decided then as a department was that maybe we need to pause instead of implementation, pause and consider other considerations in terms of the implications of implementing the Act. So in the process, there was funding that was provided by National Treasury. They provided 11.4 million for initial infrastructure development around the Act. That was also, the funds were then allocated to the two entities, NCR and NCT. So in 2019 as well, there was a regulatory impact assessment that was done, and it was also tabled in Parliament. It highlighted some areas of concerns and the unintended consequences for vulnerable consumers. So in the processes of consultations, we also had this study at the back of our minds to say we need to be mindful of some of the concerns that we raised. And then in terms of the processes, what we are now doing as a department is we are looking at amending the Act to address some of the constraints that were identified with the implementation of the Act by the consultations that we undertook. So we will be looking at amending it in some few areas before we undertake the actual implementation. So then I will then request my colleague to talk to the Protection of Investment Act of 2015. Nikki, I'm not sure if Nikki, through you, Chair, Ms. Nikki Kriya is the one that is going to present on this legislation. Just want to find out if she is on the platform to take the committee through this. Thank you, Chair.
Thank you very much, DDG. And thank you, Acting Chairperson, and good morning to all of the honourable members. As indicated, I'll be taking the committee through the Protection of Investment Act. I'll be very short, Acting Chairperson, in the interest of time. The investment policy landscape is changing globally, and both developing and developed countries are either undertaking reviews or have reviewed the investment framework as to provide an environment that facilitates investment while ensuring that governments are able to regulate in the public interest. The Protection of Investment Act is the outcome of a comprehensive review that was undertaken by the Department of Trade and Industry and Competition on the South African Investment Framework. The Act was signed into law on 15 December 2015. Subordinate regulations that dealt with mediation rules was subsequently prepared and promulgated, and the Act was then assented to by proclamation. Both the Act and the regulations simultaneously commenced on the 13th of July 2018. The objectives of the Act is really to clarify the standards of legal protections for all investors. So it's both foreign investors and domestic investors. It contains provisions that you would ordinarily find in investment treaties. And the main aim was to ensure that it's consistent with the South African Constitution and legal framework. And it reaffirms the government's commitment to maintain an open, transparent environment for investment. It adds no new obligations on investors. It ensures, very importantly, that there's a balance between the rights and obligations of investors and that and the government, and the right to regulate of the government in the public interest. It encourages investors to align their activities to support South Africa's national economic development and socio-economic transformation objectives. It provides that investors may seek protection of their investment in any competent South African court, statutory body, or independent tribunal under the Arbitration Act. And importantly, it provides a dispute avoidance mechanism in terms of the mediation that I was speaking about, where investors may raise their concerns with any decision that is taken by a government or a government agency for amicable resolution without resorting to legal challenge. The provisions of the Act, notably, as I said, include some provisions that aligns with the South African Constitution. So there's provision for expropriation and compensation that are aligned with South Africa's constitutional requirements. It provides for fair administrative action, and then confirms that any action that is taken by government should be lawful, reasonable, and procedurally fair. And it also ensures that investors can take actions taken by government to the domestic courts, and where provided for arbitration under the Arbitration Act. It, as I said, provides for mediation to avoid disputes. And just to confirm that to date, since the implementation of the Act, we have not received any specific request for mediation by any investor. The Act has been in operation for about 4 years. There's no difficulties that have been encountered in terms of the implementation and operation of the Act. And should any transpire, the need for a review will then be considered. So, Chair, that's in short the Protection of Investment Act that is in operation, in full operation. Thank you.
Chair, from Nikki's presentation, then we go to the legal metrology by Dr. Shenge Dimana.
Thank you, Chair. Thank you, DDG. And thanks to honorable members for inviting us. So the context of legal metrology. Legal metrology is part of metrology. It's one of the 3 parts of legal metrology. It's one of the 3 parts of metrology. Legal metrology focuses on requirements, regulatory requirements that are placed on measurement and measuring instruments. This is to ensure that the measuring instruments or the measurements that are taken
as accurate as is required. So the Legal Metrology Act that we are responsible for with the National Regulator for Compulsory Specification was developed to make sure that departments and government entities that may have regulatory requirements for measuring instruments are regulating as appropriately or as well as they could. If there are gaps, then the NRCS will be able to assist. So the essence of what is done in legal metrology is that regulations are developed, and in terms of those regulations, the instruments, measuring instruments will be approved or type approved. Then there will be market surveillance inspections, as well as verification that inspectors will go out and make sure that the instruments that are on the market can measure as is required. And if they are not approved, then they will remove them from the market. So in order to develop the regulations, there's consultations that have to take place with stakeholders. As I've indicated, there are departments and entities that also have a role in this space. So they have to be consulted, and we have to determine if there are any gaps that we can play a role in. So consultations were undertaken with the South African Local Government Association in connection with electricity and water meters that some of us may know that municipalities and their citizens sometimes have challenges with measurements of meters. Also, consultations were held with the Road Traffic Corporation, Management Corporation, to determine needs of measuring devices that traffic law enforcement officers use. There were also a lot of consultations with the South African Bureau of Standards, with business associations, and with other regulators as is necessary. We can go to the next one. So in terms of the progress, I think members will be aware, honorable members will be aware that the NRCS have been implementing this. So far, we have managed to develop interim measures. So in order to develop regulations, the process is to start with interim measures, and with interim measures being implemented, we can then see what is required. And once we are satisfied, then it's brought to the minister for the minister to gazette. So 10 interim measures have been developed so far. In this case, I'm just reporting the few that are the most recent that have been developed. I know that members have seen this before. They've seen the 10 that have been developed before, or the 6, because I'm giving you 4. So there's multidimensional instruments, devices that weigh while at the same time they size the dimension of an object. Such devices are used for freight measurements and loads that are on trucks, etc. There's also traffic speed measurements. Interim measurements have been developed there. There are various devices that are used for measuring speed by law enforcement officers. These include radar, laser, cameras, etc. There's also the e-tag, which is the system of classifying vehicles at open road tolling points. And this system then allows you to determine what is the size of the vehicle that is being measured, and compare that to the costs that have been set for traveling on that road. Then there's evidential breath analyzers. These devices measure blood alcohol content, especially for motorists, so that drunk driving can be reduced. So we're moving on. There are about 9 devices that are being considered for development of interim measures. We have electricity energy meters. These are the ones that municipalities use, as well as vehicle emissions and dynamic fluid measurement system. This measure other fluids other than water. And so there are 9 that are being considered. These are the most important. Can we move on to the next slide? So in conclusion, the NRCS managed to develop a number 10 in interim measures. So far, the NRCS has not proposed yet to the department for gazetting any of these and to become regulations. Once the NRCS is satisfied, they will come through to the department. So for the department, we'll continue to work with the NRCS to ensure that the Act is implemented fully. Thank you.
Thank you, Chair. That is the presentation from the department.
Okay, no, thank you very much. I think now we are done. Thank you very much for the presentation, department. Honorable members, now is our time to engage the presentation. I would see by the show of hands and note honorable members who want some clarity seeking questions and comment so that we are able to discuss and have a way forward. I can see Honorable Msuaku, number 1. Number 2, Honorable Chris Malimecha. Number 3, Honorable Dean McPherson. Or we can continue on that note, maybe and also Honorable Benson Namashe. Thank you very much. Honorable Msuaku.
Thank you very much, Chair. Thank you for this opportunity. I won't be long, my Chair. I think where I am, I've got the problem with the network. So just request that I just switched off my video. Chair, on the issue for the gambling, I wanted to check, I don't know, maybe if I got the presentation, if maybe members got the presentation, because I was trying to look in my email, but I didn't get the presentation so that you could able to prepare. Remember, some of us have just joined this committee. So it would have been nice that we have this presentation prior, and probably maybe we can be appraised in terms of what has been done, so that we can probably give a meaningful, the contribution, and also maybe bring in some new angles and dimensions to be able to take this matter forward. So we will just maybe in the future just request that, can we please get these presentations on time, even if it's a day or 2 days before, so that we can do a thorough check, so that we can advise and be able to assist proper. But on the thing of the gaming, I wanted to check. I won't be discussing the process itself. I wanted to check on that act. Is there a where does it actually protects? Is it strong in terms of protecting those who are gamblers? Remember, this thing is actually, I look at it as an exploitation of the poor, because as you all know that our grandmothers, they take all their monies and go to these casinos and sit there and waste the money and play it. Are we able to capture that into this act. Because at the end, we must just say who stands to benefit on this. Obviously, the casino owners exploiting the poor and the working class, those who don't have anything. So I wanted to ask the department, are there any of those controls, stringent controls, in terms of ensuring that, you don't have people who will go there and waste their money? Because at the end, this act must be able to protect the people out there. And also, I wanted to check with the department on what's your view on, there's this game that is done in the locations and in the informal settlements in China. Will this, China. So what does this act say about that? Are we having a control on that? Have we implemented that? And so is it, so that is the question on that act then, on the one for the gambling. On the IP Act, the department would actually guide me, is that, I'm taking it on the lessons learned from the COVID. When we wanted the IP to be used for human benefit, for the benefit of the humankind. In this IP Act, you will guide me if maybe I'm incorrect. Is it possible that, or is there a clause that captures a part where it says that this IP can be relaxed for the benefit of the humankind? And are we able to really capture that at some point, if Umugrini here has developed something that can benefit the humankind and I've got an IP on it? Did we capture anywhere that says that you can use that? The government can expropriate that and use it for the humankind if it's a sort of a medicine and all of that. And then the other one, on the Credit Act, did it capture, that majority of the people are on the credit bureau, and then there are these debt companies which are abusing this process where they buy a debt from, let's say I have a debt in Standard Bank, or I have a debt in Edgar's, wherever. And then they start chasing you and intimidate you, come to the house with guns and all of that and trying to complicate things. So is this act able to capture that? Because at some point now there's this mushrooming of these debt collectors and all of that. And also you find that you had a debt now with the Standard Bank. Now Standard Bank lists you. Now, all of a sudden, now you are listed with some law firm you don't even know. And then after 3 to 4 years, again, there's another law firm. So there's this selling of debt like that. So does this act captures that so that our poor people are not being exploited in terms of those things? One of the last questions as well, before these are just the questions of interest, is to say, when was the last review on the gambling done? There was a Gambling Review Commission report in 2011. Have there been any other reviews that were there? And the last one is that, to what extent have the recommendations of this review been adopted or implemented? And what are we doing in terms to protect against proliferation of gambling opportunities? And what controls are there? I think, let me pause there. Maybe if it's possible, get another bite, because I don't want to spend a lot of time on this issue, because I need to familiarize myself as well and get into all these, these acts. And probably if when a chair, there is a document or a summary of these acts somewhere that will give us a history, what was there, what has been amended, what are the proposal. It will probably assist the committee, especially those, some of us who are actually new to the committee. I thank you, my acting chair.
Thank you very much, Comrade Honorable Malimecha, followed by Honorable Mark Crescent and Honorable Drake.
Thank you, Acting Chair. Let me take this opportunity to also congratulate you. Good morning, colleagues. Me and the team also extend.
Yeah, morning. Can you try to raise your voice, Honorable Malimencho, because we hardly hear you. Your voice is fading a bit. Can you just?
Am I audible now? Comrade Chair?
Yeah, we are audible now. Stay there, leadership. Just there. Yes.
Good morning, colleagues. Me and the team. Let me take this opportunity to also congratulate you on a new acting post. Further extend my sincere condolences to the Herman's family. In the absence of chair, we understand what she's going through. Her loss is our loss. We wish they is comforted. Allow me to take this opportunity, Comrade Chair, to welcome this presentation. Very informative presentation that I think the department have done everything possible to ensure that it covers things that were very outstanding for some of us. However, Comrade Chair, I would want you to grant me permission to just for clarity-seeking questions of some sort. One will be some of the reasons why the provinces had problem with the National Gambling Amendment Bill was that it sought to give the National Gambling Policy Council powers to make decisions in the second meeting, while the first meeting did not have a quorum. This was bound to create problems. What was the logic behind this? If I may get that. Then the last one will be one of the challenges identified in the Consumer Protection Act is the need to extend the focus of the Act on a trade in illicit goods. However, this is not addressed in the recommendations. Why is this case? Why is this the case? And how will the Act ensure that it practically deals with illicit trade? Okay, allow me to pause there. Thank you very much.
Honorable Macpherson.
Thanks, thanks, Chair, and really our thoughts and prayers are with the Herman's family and the loss of a child. And there can be nothing more devastating than that. And that's not how it's supposed to be. And so my thoughts and prayers are really with Honourable Herman's and her family in this devastating time. And if there's anything that we can do, I hope that they will let us know. Chair, you know, there's a wonderful saying that history has no blank pages. And luckily, I'm young enough to have a fairly decent memory to remember many of the contentious conversations that have taken place in this committee and with the department regarding legislation. Because much of the legislation that has been spoken about today has very sound warnings that were made over many years that were ignored by the committee and were ignored by the department. And when many of those concerns were raised and many obvious problems with bills, we were simply told that we were politically grandstanding or scoring cheap political points or tap dancing to some masters or some other rubbish that was put before us in defense of what was the indefensible. And I want to start with the Gambling Amendment Bill, because when that bill came to this committee, I specifically warned the committee, and I said then, and it was in V119, I think it was, I specifically said there that your ANC-owned provinces will not accept this bill because it seeks to take away powers from the provinces that are legislated to them concurrently, and there are only two spaces for them to do so. One is in liquor legislation and the other one is gambling. I said, you seek to take powers away from provinces, and mark my words, your own ANC provinces will reject this bill when it gets to the NCOP. And historically, that's exactly what took place. ANC provinces rejected a bill from an ANC-run government. And just think about how historic that is. And when we warned them and when we said many of the concerns that the Honorable Malamacha has just articulated before me, they were all dismissed and they were ignored. And so we are now sitting in the problem in the space where that bill has still never been dealt with. And the department is still trying to scratch at the surface when there's many other issues that have never been dealt with within the 2008 Review Commission and within subsequent amendments, more so dealing with remote or online gambling. And that gambling continues to take place unregulated without any forms of protection for consumers in South Africa and without any possibility to generate revenue. And so while the department continues to try and save face for a failed bill, and let me tell you the reason why there is no mediation or the meetings are being cancelled of mediation, because no province wants to actually mediate in this process. They don't want this bill. And really, Chair, I think that it is another lesson, and unfortunately, we seem to continue to want to learn a lot of lessons in this committee, that maybe for once, the committee should listen to opposition MPs, listen to their concerns, and stop dismissing them just because they come from the opposition. Because I warned this committee that this is exactly what would happen, and that is exactly what has happened. The department, I warned the department then in 2018, and they chose to steamroll the amendment through because they wanted something to be able to tick the boxes to justify their bonuses and to say that they were actually doing something in terms of legislation. It was garbage then, and it is garbage now. We should be going back to the drawing board. But luckily, I have saved the department some time and have formulated the remote gambling bill, which I have reintroduced into Parliament as a private member's bill, and I'm sure that they are going to support it because all of the ANC-run provinces now support the bill. Then I'd like to turn my attention to the National Credit Amendment Bill. And I think it is hilarious that on page 41, the department finally admits that there are implementation problems with the bill and its cost effectiveness. And a review is now taking place of the bill. And we warned then when this bill came towards Parliament, again, just before the elections, that this was nothing other than an election bill. It was unimplementable, and they were never going to get the funding for it. Again, unfortunately, members of this committee chose to ignore us, called us all sorts of names, and decided to proceed with the bill. Again, the department ignored all of our concerns and proceeded with the bill. 3 years later, the bill has not been implemented because they have finally woken up to exactly what we told them then 4 years ago, that this bill was not workable, and there was no funding that existed for it. So, I have very little sympathy for the department that is now effectively trying to dump bills on our desk 18 months before an election because they have very little to show for what they've done over the last 3 years. And I think, Chair, that there is a time that must come in this committee where we actually deal with bills as honest brokers, where we actually decide and hopefully want to listen to members of the opposition, because we say things not because we have nothing better to do, than because we actually have real concerns over issues of bills, their implementability and their effectiveness. And those are just two examples of bills that have stalled and have actually gone nowhere. And I think it should be a real shame on members of this committee that were in the Fifth Parliament and the department that we find ourselves in the position that we do today. Turning to the Promotion and Protection of Investment Acts, which ironically does neither of the two stated objectives. The reason we were told that we had to have this act then is that South Africa was going to stop concluding bilateral investment treaties, yet has continued to bilateral investment treaties. So I'd like to know from the department, why is it that there is one form of protection that is offered to countries that we seek to install bilateral investment treaties with, and then we subject other countries to the Promotion and Protection of Investment Act, which does neither? Thank you very much.
Thank you, Chair. Can we have Honorable Benson Namashe, followed by Honorable James?
Thank you very much, Honorable Chairperson, and once again, I really want to congratulate you for the acting capacity, and also welcome the presentation by the department. Chair, I will not be long owing to the challenges with my voice. I'm not sure if I cannot switch off my, or rather, I may as well continue. Chair, we all know that access to finance in South Africa has always been predicated on the policy compendium that is entirely entrenched on capitalist propositions. And over and above that, it has been a contentious matter which has always been racialized. And therefore, as an important transformational imperative, it has always been important to make sure that we develop a legislative regime that is able to redress that kind of a historical injustice and begin to come up with legislative instruments that place the working class at the center in terms of access to resources. Well, that's how we will change the socio-economic challenges of different households. Now, if you look into the National Credit Act, perhaps it may be relevant to ask this question as to how does the National Credit Act correct the challenges of debt review faced by most working class people? Many people, Chair, after being placed under debt review, they struggle to get the names removed from debt review, which limits their ability to apply for credit in the future. And this is very, 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 very critical. It talks to the heart of what I just prefaced with. The second question, Chair, also linked to that, what happens when the debt councillor determines that the credit advanced to a debtor was reckless? So you do find that those kind of situations. And so in other words, what would be the recourse or the remedy sought from the court once this is reported? there are credit providers that are unscrupulous and notorious about this. The third question, Chair. We do note the recommendations of the regulatory impact assessment of the National Credit Amendment Act to the NCB. You know, where it indicates that the Act has areas that could impact the economy and have unintended consequences. So can we get clarity on the specifics of how this will negatively impact the economy and vulnerable consumers? We have a responsibility, Chair, to make sure that the consumer is protected from the hawkish tendencies of those who are in control of the production, which by extension they are in control of the value chains, which ultimately affect our people negatively. And the last question, Chair. If we observe, since the enactment of the Protection of Investment Act, one is tempted to ask a question as to how has this had a positive impact on foreign direct investment in the country? And linked to that, how different and efficient has this legislation proven to be from bilateral investment treaties? This is also very critical, because these treaties must be able to respond to fundamental economic challenges as they would relate to investment opportunities. Thank you very much, Chair.
Chair, can I proceed?
Yeah, continue, Mr. Tring.
Thank you, Chair. Chair, firstly, the ACDP also wishes to offer its condolences to the Honourable Hermans and the family. Indeed, I think it ought to be children who bury their parents and not the other way around. So our condolences and prayers go to the Hermans family at their time of loss and bereavement. Chair, just maybe 4 questions, and I'll try to just be specific with regards to these questions. The first is with regards to the National Gambling Act. I think it's common knowledge that gambling has a devastating effect on families, particularly where a member or members have become addicted to gambling. And so certainly one wishes to put in place measures to actually limit the negative impact that gambling has on families. Now, with that said, what enforcement measures are in place? So legislation is there. The challenge is sometimes with enforcement. And what are the enforcement measures that are in place to ensure or to prevent the overstimulation for latent gamblers, particularly children and perhaps even young adults? You know, as an example, you sometimes have adverts which will say, don't drink and drive. And then at prime time, this is family time, you'll have another advert saying, down a lion, feel satisfied. So there are these mixed messages that sometimes also go out. And we talk about reducing overstimulation. But then we sometimes have adverts on gambling that are also at prime family time, which can also target children and young adults. So what are the measures, if any, that are in place to reduce this overstimulation for latent gamblers? Secondly, what is the consideration given? What consideration has been given to the combining of the lottery and the National Gambling Boards Commission into boards or commission into one entity? I believe that this recommendation has been laid on the table, and has any thought been given to this particular consideration? And then with regards to the RIA, the Regulatory Impact Assessments on the Consumer Property Act or Consumer Protection Act, what timeframes are there for this regulatory impact assessment to be concluded? And then my last question is with regards to the Intellectual Property Laws Amendment Act. Are there, or what interim measures are currently in place to prevent the abuse of indigenous knowledge, cultural indigenous knowledge, art, designs? You know, you see some of these designs can only be found in some of your deep rural areas. But somehow these designs or indigenous knowledge which belongs to our communities, our indigenous communities, our local communities, somehow these designs are found in Paris, Milan, Tokyo, New York, London, and so on. And so what kind of interim measures, if any, are in place to prevent the abuse or the theft of indigenous knowledge? Thank you. Thank you, Chair.
Thank you very much. I think the DG is able to see the questions from the chat. Or can you please assist us, Honorable Secretariat Andre, to read through the question from the chat from Honorable Motau? Then we'll hand over to the DM and the team for response. Thank you.
Chair, with regard to the question on the chat, the question is, since the enactment of the Protection Investment Act, how has this had a positive impact on foreign direct investment in the country? Secondly, how different and efficient has this legislation proven to be from a bilateral investment treaty perspective? Thanks, Chair.
Okay, no, thank you very much. DM, you will guide in terms of the response, and while if those response cannot be dealt with, I think it will be proper as well for the department to can write them down and forward to the Secretariat for members to get their clarity seeking question. Thank you, DM. Over to you.
Thanks very much, Honorable Chair. Chairperson, there are broad comments that the honorable members have made that I would like to come back to comment on. But I would like to suggest that we go back to the acting DG, would hand over to Dr. Masota firstly to answer the specific questions that the honorable members have raised. And there are representatives from our different entities, so they may give explanations to some of the specific questions that the honorable members have asked. So I will ask the acting DG to guide us through the responses, and with your permission, Chair, I can respond to some of the issues honorable my share and the Honorable Macpherson had raised the broader questions that they raised at the end of the answer session. So with your permission, if we can go back to the acting DG, Honorable Chair.
Thank you, Deputy Minister. Chairperson, there were a number of questions posed around gambling, mainly in the area of how do we protect the vulnerable and what are the enforcement measures in place. I will ask Dr. Evelyn Musocha, and I do know the colleagues from the National Gambling Board are in the room. They'll be able to provide a lot more color to exactly what's being done there. On the issue of intellectual property, I think the question that Honorable Swaku raised around intellectual property used for humankind, Chair, what I would like to maybe just also kindly request Ms. Nikki Kruger as well to also indicate the work that the team has done at the World Trade Organization in terms of the TRIPS waiver, in which vaccines were then allowed to be produced in countries during the period of the pandemic. And I think that is a very good example of how intellectual property and the TRIPS waiver has assisted in that regard. The issues around the National Credit Amendment Bill, I think Honourable Macpherson has raised that, as well as remote and online gambling. Evelyn will touch on that. But Chair, on the Protection of the Investment Act, what I want to indicate is that there is quite a considerable bit of work that's been done in this area. South Africa is in the process of terminating those bits which would then expire. All bits have had an expiration date, and obviously with the introduction of the Act, we couldn't immediately terminate all bits. But there's a considerable bit of work being done at the moment. For example, in the Africa Continental Free Trade negotiations, the team has already started negotiating a protocol on investment, which will then regulate how investment will be dealt with on the continent. So there is a lot of work being done in that area, and Nikki will also be able to expand on that. Chair, and then the one around the combination of the National Lotteries Commission and the National Gambling Board, the question by Honourable Tring. Chair, you would see also in our annual performance plan in the current financial year, the Minister has indicated that there's two areas which we are looking as a department to sort of consolidate the work. The first one being reducing the number of programs or branches within the department, and the second one is in the area of the entities. So there is currently research being undertaken to understand, or work being undertaken to understand exactly which areas can be consolidated. And obviously the area of lotteries and gambling is one specific area, but obviously that work is still being undertaken, and once that is clear, the necessary regulatory processes will then unfold. Chair, with your permission, I would then like to hand over to firstly Dr. Evelyn Musocha, and then to Ms. Nikki Kruger immediately thereafter to then respond to the very specific questions. And if the National Gambling Board, I think a lot of questions around gambling, if they would like to also add to what Evelyn has to say. Thank you, Chair. If I can then invite Evelyn.
Thank you, Acting DG. Thank you, Chairperson, and thank you, honourable members, for those questions. I will respond to some of them, and then I will indicate the colleagues from the entities who will also assist with the other questions. I think for the order, maybe after I finish, Nikki can then speak, and then I'll indicate the names of the other colleagues who can follow from there. So starting with the questions by Honorable Tswaku. Honorable Tswaku, I've noted your concerns related to the protection of our communities when it comes to gambling, and the fact that the vulnerable people end up using their limited resources, finances to go to gamble at casinos. It is a concern. And in terms of the National Gambling Amendment Bill, the current bill, this issue is not addressed directly in that bill. But with the National Gambling Act and other programs we have as government and the National NGB, we do have instances where we do education and awareness when we talk to communities about issues of gambling, as an example of some of the measures that we have. And there is a link we have with the National Gambling Responsible Program that also looks at supporting persons who are affected by gambling-related issues, especially when it comes to issues of gambling addictions. This area is one of the issues that requires ongoing support, ongoing engagement with the communities, because it's not although it can be legislated, it talks to human behavior. When a parent receives a grant for social to assist with the livelihood, they take that money, then they go and they gamble with that. So it may not necessarily be a legislative issue per se, although it talks to protection, but it talks to the behavior and education about gambling, its implications, the fact that it's a harmful activity that can lead to issues of addiction, and have other consequences that were not anticipated. But we have noted this also for further consideration in terms of what are the other options, what we can look at to reach out more to communities, to talk to them about the harmful effects of gambling, even though they see it as an opportunity to make more income. Another gambling mode that has a potential of addiction in that manner is the lotteries. And the thing about it is that because of the amount, when you buy these tickets, it may not seem like much, but it also has that similar kind of effect. So it's a very important question that you've raised, Honorable Tswaku. On the question of FAFI, this matter is currently FAFI is an illegal gambling activity in the country. FAFI is not legislated. Regulators, NLC, for instance, does look at issues of FAFI as it's linked closely to the issues of the lotteries. They do look at the FAFI issue in terms of from their research, from research, but also in terms of engaging with other regulators around these issues. The way we look at FAFI currently is from an illegal gambling context. It's an illegal gambling activity. So those who are found participating in it, it will be from an illegal perspective. So it's not allowed. And I know that regulators are grappling with FAFI. They're looking at ways that it can be combated. So from an illegal gambling activity perspective, this is one of the areas that we are grappling with. But I do know that regulators are looking at it, especially the NLC, from the engagements we've had with them. They are monitoring the situation of FAFI. There's always room, of course, for tightening some of these areas in the legislation. So the issue of FAFI is noted as part of the questions that were raised. For Mr. Marime, okay, let me get to, okay. For Mr. Marimeja, on the issue of the gambling as well, and the legislation, what has happened, I will talk to the issue of the National Gambling Policy Council, to indicate that on the issue of the National Gambling Policy Council, it's a very, one can look at it from an administrative perspective to say it's only a meeting. And the quorum, and of course, what is the main issue with the quorum? The problem with that is that when you need to make key policy decisions, and the policy decisions have got implications for how you set the structure of protection, of setting the scene in the country on a matter of gambling, for instance, you do need buy-in from provinces because of the concurrent nature of the function, and so of the mandate. So the norms and standards and having different provinces agreeing on a way forward is very critical. So it has been a challenge that there has not been a quorum over many years, in some instances where decisions cannot be taken, but they're noted. So certain changes cannot happen because we need a uniform approach across the provinces and the national. So the logic has been that maybe by making a stronger point of imposing that if in the first meeting there was no agreement, there was no quorum. In the next meeting, even if there's no quorum of 5 MECs and the minister, a decision can still be taken because of the importance of a policy decision that is required. So that is where the logic is coming from. Other options were tried. For example, repeatedly confirming, checking, is the MEC available, and only to find that they've been confirming, but on the last day, they are not coming, or they send an apology in the morning, the MEC has to go to another engagement. So the quorum has affected how the Policy Council operates in general. And so we think that this was a proposal that was put on the table to assist, to ensure that there's harmonization and control in terms of the regulation of gambling in the country in a concurrent environment that we find ourselves in because of the Constitution. In terms of the illicit goods, the recommendations that we made in the slides, we emphasize some of the areas. They are not like final areas. They're just some of the options that the research identified as options for further consideration. We are still going to look at the different options that were presented in the regulatory impact assessment study. And part of on the illicit goods, for example, we'll look at the options of inspections, the role of the NCC, the role of other regulators. How does it interrelate with other regulators that deals with illicit goods? So in terms of why the recommendation is not on the other slide, is because we're just highlighting to the members, honorable members, these are some of the issues that came from the research, but it's not cast in stone. There's still further public participation that we need to do to get to the final options that will then be presented in the public, also presented ultimately to the committee at some point. So I just wanted to just highlight there to say that we just brought them there to show that something was done. There was a regulatory impact study. It's out there, and we are finalizing it and we are working now on looking at the different options and also looking at consulting with stakeholders. And coming back to some of the points raised by Honorable Tswaku, the DG spoke to the issue of the Patents Act when it comes to the human benefit. For instance, on medicine is related to the patents, and I know that my colleague Nikki will speak to that issue. It does not come in the issues around the Intellectual Property Laws Amendment Act, but it's an important point that I've noted. Also, on the credit bureaus and the abuse when they buy debts from other suppliers, and then they then put the burden on the consumer. This issue will then allocate it to my colleague Tupang Maholeho from the NCR to talk to that in terms of more practical implementation perspective of what they do about such incidences when they happen. Also, she will also talk about the selling of debts when the debt is being sold. What are the implications because of the exploitation that sometimes occur to the consumer? In the current amendment bill for the Amendment Act, this issue is not addressed there, but I know that is one of the areas that we also are looking at for strengthening in the future amendments. But I know that as the regulator, there's work that they may be doing around these areas that they can speak to in a more tangible manner to assist with what we are doing collectively to address this issue. Honorable McPherson, I want to thank you for the input you've made today. I think in terms of legislative development and policy making, we need to listen to all voices. And it's correct to also say that when there is criticism of what we do, sometimes a critique can help to improve a process. So I noted all the inputs you've made and the journey you took the committee through on what happened with the department and what has also happened with the role of the committee. There's always lessons to be learned, and I think that going forward, there are things that we can strengthen based on this wisdom received from persons like yourselves who know the historical context of issues and where things can be. And we've noted the private members bill that has been gazetted, that has been put out. We've noted it, and it's something that we will also engage with by the department. So we've noted it, and to say that we will participate in those processes. And thank you for your contribution to this debate. We can only strengthen our work going forward. Honorable McPherson asked a question about why is there one form of protection for other countries when it comes to the investment legislation. Ms. Nikki will talk to that point as well around the protection and the differentiation around the different countries. Honorable Twaku also asked about the review of the Gambling Act.
Sorry, Dr. Masoji. As I indicated earlier on that I'm in transit, can I request Honorable Benson Namashe to continue with the remainder of the sitting until I'm done with the meeting. Thank you very much.
Thank you, Chair.
Thank you, Chair. It's just that my voice is hoarse. I can continue with the meeting.
Thank you, Chair. Okay, so on the issue of when was the last review of the gambling done? It was in 2011, Honorable Twaku, as you've indicated, and some of the recommendations that were in that in the review they were taken into consideration. It looked at different modes of gambling. It also looked at how we need to move forward based on the new modes of gambling that were identified, that were coming into the picture. It talked to different aspects of gambling, and of course we had to consider them and look at how best we move forward. As we move to the next phases of reviewing the law in terms of the National Gambling Act, we could also go back to some of them and review them further, because it was at a particular point in time when we were looking at the current situation where we were at the time. So much has happened since then to now, and there's been different developments. Our country has moved to different areas, so there's room for further review and to take some of the recommendations forward. But we did take them into account. One of the main considerations was around the balancing of extending new modes of gambling, the economic implications of the gambling situation in the country, and also protection, and ensuring that there is a clearer and strengthened regulatory framework in the country for gambling. So in terms of the protection of the public, we continuously identify measures to look at how to protect the public against the harmful effects of gambling. And I think that my colleague, Mr. Ngwadze Mashamaite, will talk to some of the practical things that are being dealt with by the National Gambling Board to look at implementation of some of the programs dealing with support to the communities around gambling. Also, we do our own education awareness from time to time, going into the public communities, rural communities, talking to some of these issues around gambling, because it is a societal issue, and also talking to the behaviors around the way gambling is looked at. In terms of Chair, your questions around and the comments around the role of credit on transformation, on the economy, on uplifting our society, of changing the historical context, of ensuring that there are more benefits. Those points have been noted. And if the questions you've raised is around getting out of debt review for consumers who struggle to get out of debt review, who end up not being able to have access to credit, and also what happens when what happens when debt counselors they are reckless. So what happens when there's recklessness? What is the role of debt counselors, and what recourse is available? I've noted those questions, and I would prefer that Ms. Ntupama Khulego addresses them from the way that the regulator, NCR, deals with these issues when they come across. I think it's important that they provide that practical implementation level of how they deal with some of these issues when they come. Then on the regulatory impact assessment, the unintended consequences that were identified in the research. Some of them, Mr. McPherson did mention them. For example, the issue of the cost to the economy, the cost of this to the fiscus. There will be a cost to government, because that intervention legislation is meant to be for free for the consumers. Instead of them having to also be charged, it was intended to be free, and the role of the regulators, the administration of it, and the processes and everything. So the cost to the fiscus. Another notable point raised was the cost to the cost of credit to the vulnerable consumer. One of the most notable point was that as much as the Act is intended to protect consumers, the implications are it was going to make them worse off, because the financial services sector, the industry, was going to have a challenge with consumers who are not able to, who are at risk in terms of meeting their obligations. So while it was intended to be a process that simplifies things for consumers, they can rearrange their debts, it was also going to make them vulnerable, because now the financial sector will avoid that target group, and then there will be implications for the informal mashonistas now, who will then exploit the situation. So the research did highlight other issues around the costing of this process to the economy, and how it can even affect the perception around the macroeconomy. So we did take them into consideration, and we were also thinking that we need to be prudent, given that the economy as it stands has faced so many challenges. And recently, with the different developments, when in 2019, we did not have the hindsight of now, when there has been other developments that occurred, from COVID to the unrest and the floods. And so the implications are more now where we are as a country. So I think that we took that into consideration, the challenges with the implications, the possible implications. And going to Honorable Sring on the issues around the issues around gambling, the adverts that do come across without the proper warnings, and the vulnerability of young children and teenagers. I'm going to also ask Mr. Nkwadze Mashamaite to talk to this issue around what is it that, as a regulator, NGB, they are doing around the issues of advertising, and looking at how to address protection of children and vulnerable persons from overstimulation of gambling. So I would prefer that we address them not from a theoretical legislative point of view, but from a practical implication perspective. So Mr. Nkwadze, please note these questions around vulnerability, measures in place to address the overstimulation, plus the issues of adverts. What are we doing around those? And the question that was also asked was, what is being done about the National Gambling Board and the National Lotteries Commission? We have started looking at this question, and as the DG has indicated, the department is also looking at fit for purpose structure, not only in terms of the internal department, but the entities as well, for being effective, a more effective organization. So this debate is ongoing. We did a study on the lotteries as well, and this also was one of the areas that we looked at in terms of the possibilities around that. So we have started looking into this issue. It's an important area, and even the regulators have given an indication to some extent what they think about it. So we are doing something, Honorable Sring, and hopefully sooner there will be more direction in terms of the way forward around this possibility. So it's not yet a decision, it's just a discussion on the table that is being assessed, and the implications of it and what it could mean for the shape of the regulatory institutional mechanism in the country. On the regulatory impact assessment for the Consumer Protection Act, we have not yet set timelines, Honorable Sring, but we have started with the development of looking at the policy options. And we will be undertaking a policy process around this and engaging with experts and other stakeholders and other bodies to ensure that we address the options, and we start to look at how do we then take the work that was done forward. The regulatory impact study was completed in 2021 around March, so we completed it. So now we are looking at taking it further in terms of the policy development process and looking into the different options that are out in the to look at how to strengthen the current legislation, the CPA. And on the Intellectual Property Laws Amendment Act, the measures in place to protect the exploitation of the traditional intellectual property, wherein they are exploited, they are found in other countries like Paris, Milan, Tokyo. On that point, it is a concern, and that's why we had to come up with the legislative framework, because measures have to be, especially in a regulated type of industry, they have to be supported by regulations. So this act was intended to ensure that further protection. Now that it is not yet in force, it's an area of concern, it's a gap. And even the Department of Science and Innovation, their legislation is looking at this to a large extent as well. So I think that there are different roles that different departments are playing around this, like DSI, but from a CIPC point of view, I will ask my colleagues, Dr. Kwele and Ms. Nomonde Maimela, to maybe talk to what have they been doing around this area, especially some other measures, not necessarily legislative, in terms of protecting the traditional knowledge of the traditional knowledge around the exploitation of our society on their IP knowledge and so on. I know that their work was going to be informed more by the legislation, but in case there is certain measures they have, they can just share their perspective around that issue. So, Chair, from my side, I think these are all the questions that I managed to identify from the discussions. And from the order that the DG has given, Ms. Kruger will speak to her areas of Investment Act. And following from her, I will then recommend that we start with Ms. Ntupang Mahuleho to speak to the issues around debt review, exploitation, selling of debt, and also to speak to the issues after her. It will be Mr. Nkwadza Maide to talk to the implementation and the measures by the National Gambling Board on issues of gambling. Thank you, Chair and honorable members. I will stop there and then hand over back to you, Chair.
Thank you very much, Dr. Masoja. Can we follow the order as you have advised, and make sure that whoever is presenting is also cognizant of the time and the challenges of connectivity? Thank you.
Thank you very much, Honourable Chair. I'll be very quick in the interest of time, as you've indicated. The acting DG has asked that I also just talk briefly about the TRIPS waiver in the WTO, and then there was 2 questions on investment, the protection of investment bill in relation to the termination of bilateral investment treaties, and then the impact of the Protection of Investment Act. In terms of the TRIPS waiver that the acting DG has asked me to talk about, TRIPS, as the honourable members will know, is the agreement on trade-related aspects of intellectual property rights that is an international legal agreement between all the members of the World Trade Organization. In last year, South Africa and India proposed a TRIPS waiver in the World Trade Organization for purposes of COVID. And at the 12th Ministerial Conference that happened in June, WTO Ministerial Conference that happened in June this year, a ministerial decision was taken in terms of the waiver. And basically what the waiver provides for, or this agreement provides for, is that it allows governments to authorize local manufacturers to produce vaccines or the ingredients, substances or elements, and utilize processes which are covered by patents without the permission of the patent holder during the pandemic. It also allows for exports of these products that are then so manufactured. Chair, in terms of this, maybe just to quickly highlight that the department has prepared a patent bill, and that this patent bill will be coming shortly to the portfolio committee for further consideration. In terms of the questions on the Protection of Investment Act, there was a question from Honourable McPherson in terms of bilateral investment treaties and why only some bilateral investment treaties has been terminated and why some countries are protected under bilateral investment treaties and others are protected under the Investment Act. I want to first just clarify that all investment, whether from any country and also domestic investment, is protected under the Protection of Investment Act. It is correct that there is still some bilateral investment treaties that is in place. We have started the termination process of the bilateral investment treaties, and these treaties really provide for fixed term periods that they are in place, and either it's then renewed automatically for another fixed term, or it is then continues until after a fixed period until it is terminated in line with the provisions of the specific bilateral investment treaty. So using the specific provisions in the different bilateral investment treaties, the termination process has started for what we will call the so-called first generation bilateral investment treaties, and that process is still ongoing. So there's not different treatments for different countries. The first bilateral investment treaties that we entered into was mostly with European countries. So those are the first where we started terminating in terms of the fixed term periods that was set out in those agreements. As the acting DG has indicated, in relation to our bilateral investment treaties with African countries, these are being dealt with under the current negotiations that is ongoing on the African Continental Free Trade Agreement, where we have started to negotiate also an investment protocol. In relation to the question from Honourable Motaeng in terms of the impact of the Protection of Investment Act and how it may be different or better than the bilateral investment treaties, we should keep in mind that it is not only, of course, the Protection of Investment Act or that sets the framework for investment. Global conditions and economic growth is also factors that should be taken into account that affect investment flows. Investors want to know that there's a robust legal system in place protecting investment when they invest. South Africa provides such an environment under the Protection of Investment Act, under the Constitution. We are a mature foreign direct investment economy, and foreign investors are already well established across all of the sectors of the economy. Importantly, what should be recalled is that since the implementation of the Protection of Investment Act in 2018 and the start of the President's investment mobilization drive, 1.1 trillion of investment was attracted to South Africa. As I've indicated during the presentation, we have not received any specific concerns from investors in regard to the implementation of the Protection of Investment Act. They actively still invest in South Africa. The Act also provides for mediation provisions that can be used by investors when they do have any concerns. And these provisions are implemented in close cooperation with Invest South Africa to ensure that investors' concerns are addressed. And I think it can be seen with the type of investment that we've attracted over the last 4 years, the amount and the sectors where investment is taking place, that the the Protection of Investment Act do put in place a very attractive framework. We can respond further and more details in writing, Chair, in the interest of time. Thank you very much.
Let's proceed with that order. The next presenter.
Thank you, Chairperson. My name is Nchupang Mahuleho. I represent the National Credit Regulator. There were 3 questions that were posed that relate directly to the work of the National Credit Regulator. The first one is the selling of debts, and the second one being, and the last one being the outcome of instances where debt cancellors find a credit agreement to be reckless. What recourse can they obtain for consumers?
You seem to have frozen.
Chair, through you, can we take the next presenter? I think is the colleague from the National Gambling Board, in the interest of time.
Yeah, because she seems to have frozen.
Yes.
Yes. Yeah. Can we do that?
Apologies, it looks like I got disconnected. So on the question of the selling of debts, just to be quick, legislation has already identified that there are exploitations related to the selling of debts, which is why a provision was introduced in 2015, trying to cap some of the exploitation. This provision essentially deals with the selling of prescribed debts. It was identified that some credit providers tend to sell debts that are over 3 years old, and in terms of the Prescription Act, they are essentially not allowed to collect those debts. So in terms of the new provision now, it is actually a prohibited conduct for a credit provider to sell to another person, be it a debt collector or a new credit provider, a debt that has already prescribed. So to a certain extent, some of the exploitations relating to the selling of debt are already being dealt with under the current legislation, the National Credit Act. On the second question of exiting debt review, the challenges relating to this issue of exiting debt review have been dealt with also currently under the law. Firstly, in terms of the National Credit Act, consumers who apply for debt review are able to exit debt review once they pay all their debts that are related to the debt review application. But secondly, the courts have already also granted some kind of guidelines in terms of consumers who believe they are no longer over-indebted. So for those consumers who believe they are no longer over-indebted, the courts have already provided a guideline to say that those consumers who believe they are no longer over-indebted can provide the proof to the court so that the court can then declare them no longer over-indebted and therefore exit debt review. So under the current legal framework, there is mechanisms in place that allow consumers to exit debt review. Those who possibly are not able to exit currently, it's either because they are still over-indebted and they deserve to continue to be protected under the debt review mechanism, or there are those who are placed under debt review fraudulently by debt cancellors, and those are dealt with in terms of the enforcement mandate of the National Credit Act, where we are able to approach the National Consumer Tribunal to obtain orders that will force the debt cancellors that places consumers fraudulently under debt review to remove them from debt cancelling. And lastly, on the question of the redress that is available to consumers who that councillors have identified that some of their credit agreements have been granted recklessly. In terms of the National Credit Act, there are various redresses that are available, one of which is that if a credit agreement is found to be reckless by a court of law or the tribunal, the court can set aside the obligations of the consumer. Essentially, the court can say the debt is no longer payable by the consumer. So those would be the questions that related to the National Credit Regulator. Thank you, Chairperson.
Thank you very much. An informative response. In fact, I'm quite impressed with the library behind you. It inspires confidence. Keep it up. I hope that those books are read. And I'm sure members will agree with me if I say there's a strong necessity that outreach programs should be the order of the day, so as to empower our people with information, especially where our people are taken for a ride. Prescribed debts are sold so as to illicitly gain out of those kind of transactions. It's important to share those that kind of information. Thank you very much. I take it that it's the last presenter.
Chair, there is Mr. Nkwatse Mashamaite from the National Gambling Board, because there were several questions on the gambling mandate, and I forgot to mention the CIPC colleagues who can talk to the issues of the IP law and how they are currently addressing some of the issues, even without the legislative framework that we're trying to address. So I request that after Nkwatse, Ms. Nomonde and Dr. Kwele, they can talk to that issue. Thank you.
Okay.
Good morning, honorable members and colleagues from the DTI. Thanks for this opportunity. My name is Nkwatse Mashamaite. I work for the National Gambling Board. In response to issues that were raised, mostly it was about the protection of our people. First, I'll just indicate that most of this is actually built in the gambling policy, the national gambling policy, as guided by the principles that were indicated in slide number 7, the Viahan Commission principles, mostly that we must protect the vulnerables from the latent harms that is associated with gambling, and that we must regulate gambling strictly to ensure the dignity and protection of the gamblers as well. So in dealing with the issues of the vulnerable, mostly you will note that we have limited opportunities for gambling in the country. In terms of policy, we have got a limited number of casinos that are permitted, and we have up to 41 licenses that are allowed to operate in the country, although not all 41 licenses are operational at the moment. And we have got limited payout machines, which were slot machines that were permitted to be played outside casinos, but they were limited in that people can only gamble a bet with at least 5 friends at a time, and they can win up to 500 rands per game. And this is the limitation just because the slot machines are outside casinos, and people should not actually be frequenting them a lot and getting the opportunity that they will get in casinos. Sorry, is there?
No, Pat is judging. He knows that wherever we meet, that is on.
Sorry?
I'm still in charge.
Okay.
Can I request that whatever input is being made it is done through the chairperson so that there is order.
Can I proceed, Chair?
Proceed.
Yeah. No, I was just giving a brief background in terms of what protections are there in the legislation. In terms of what we do ourselves as the National Gambling Board, we do oversight on the provinces. The provinces are the ones who issue licenses to casinos, and they issue conditions for those licenses. And we conduct oversight, compliance oversight on provinces. We go there on inspection regularly to check that they do follow the principles that are in the National Gambling Act. And one of them is to ensure that they ensure that these people in their premises, they indicate that the place is allowing only people over the age of 18 to participate. And secondly, that there is a help for people who might find themselves addicted to gambling. They can actually seek that help with the message that winners note when to stop, also displayed in the entrances as well. The other part that we also engage on is dispute resolution process. We also expect, when we do compliance oversight, to see that that information is actually displayed so that gamblers can see when there is a dispute, where do we go to lodge that? First, it will be with the internal processing the licensed premises, and it will go to the provinces, provincial board. If they are not happy, it will be escalated to us, and we will try to mediate to ensure that a proper resolution is adopted in that regard. So this is basically what we do, trying to deal with those issues. We should recognize that in South Africa, the Constitution also allows a number of freedoms, and those freedoms include that you can't just tell a person that you cannot go and gamble. And hence, our legislation came up with the safeguard to say, if you feel that you are more vulnerable yourself, that you're getting addicted to gambling, you can actually apply to have your name excluded from gambling, and that you cannot be allowed to gamble for a certain period. You will apply to be readmitted at a later stage. This process also includes that third parties can also approach the relevant authorities for that assistance as well. If they see that a family member of theirs is also addicted, of course, he wouldn't admit that they have a problem. So they will actually also get their names enlisted. At the moment, this is applied informally, as we are still finalizing the process. The process of regulations are still being finalized to introduce this provision, Section 14 of the Act, so that it is implemented properly. In that, when it is implemented, we will have a national register where all licensed operators can see names of people who have excluded themselves and their pictures, and then they will also implement measures to ensure that those people are not allowed on the gambling floor. At the moment, it is applicable, but informally, so it applies per license holder, and people will actually be excluded in terms of where they have applied. And this is one of the safeguards to try and prevent issues of addictive gambling. And we have partnered with the South African Responsible Gambling Foundation, an organization that is funded by the licensed operators in the country, who contribute 0.1% of their gross gambling revenue towards funding this organization. It provides free counseling treatment service to addicted people who have problem gambling that need assistance. We have a toll-free line that people can actually contact to get assistance as well. It must also be noted, as indicated earlier by Dr. Masocha, we conduct education and awareness, and in that we try to educate our people that it is actually wrong to gamble with illegal operators, number one, because they can get arrested. The provisions in the Act requires that one can actually be sentenced to a period not exceeding 10 years
or be fined to a fine that is not exceeding 10 million. So this is the things that we also teach our people, that be careful, do not gamble with illegal operators in the country. Instead, report them to the police, who will actually go and arrest those people and then have them also pay for conducting these illegal activities in the country. And they are also alerted that if you gamble with an illegal operator, your winnings might not be paid to you, because when the banks receive notification that they should pay you, they will first notify the National Gambling Board, who will do the investigation in terms of Section 16 of the Act. And in that investigation, if we find that the proceeds are from an illegal activity, the money will be forfeited to the state through the courts. And that is basically what will happen. And unfortunately, it is the gamblers who will lose more, because they would have lost before they won the winnings that they have received. But yeah, in terms of the Act, those winnings will be confiscated and they will be forfeited to the states. And banks work with us. They do notify us about this kind of winnings, and we actually do investigate and get the money forfeited to the states. We have actually been doing that recently. And the other one is that on advertising, yes, there is a legislative provision nationally that requires that advertising must be responsible, and it must not be extended to vulnerable people. And yes, advertising in peak hours is something that we also deal with. But as indicated, we do oversight, and as part of our oversight is to engage with the provinces to try and say, please, when you see these adverts, you need to speak to your licensees to actually stop it and flight it at a reasonable time where vulnerable people are not still watching at the time of that. I think I have tried to cover everything that was indicated here, where it concerns me. And yes, the other part, sorry, this is the last one. We are also responsible for assisting the provinces with dealing with enforcement against illegal gambling operations. And China, as it was indicated, or FAFI, as it is also known in the formalized sector, is an illegal gambling activity that is not regulated in the country. And when provinces deal with that, they also engage with us to try and manage the issue of illegal gambling, making sure that we are enforcing against these illegal operators. And at the moment, the National Gambling Board is on a national drive. We are actually establishing committees, enforcement committees that will deal with illegal gambling. We are working with the police and setting up in every province with them and the National Prosecuting Authority, including the Financial Intelligence Center, and all other stakeholders that are very much relevant in our quest, including the National Lotteries Commission, to try and combat illegal gambling in the country. And we are actually seeing positive approach, because there are a number of people that get arrested on illegal gambling activities, and there is a number of cases that are in court. But we believe that the police are very much in support of this initiative, and it will actually yield results that might help us to eliminate even our cyber illegal operators in the online gambling spaces. Thank you.
The next person is Nomonde Maimela with her colleague, Dr. Kwele.
Yes, I've already said so. Okay. I hope they will also be as short as this.
Okay, I'll be brief. Thank you, Chairperson, for the opportunity. Thank you, DDG Masoja, for the opportunity to respond on intellectual property related issues. Let me say that the Intellectual Property Law Amendment Act actually provides and deepens the necessity for registering of copyright related to our culture and indigenous knowledge. Copyright, it also enables us to register trademark and designs that are indigenous. So we are actually working with the DSI as well as the department here to actually enable that to happen, so that we can get protection or we can get protection for indigenous related designs or copyright that are South African. So that, because we believe that protecting them under IP will be more effective, in that, you know, as you know, that IP registration actually details who the owner of IP is. So this will enable, you know, our communities to actually be identified as owners of these cultural designs that we are talking about. So we already have something that we are doing in the area of patents, where we force those who are registering patents related to genetic resources to actually declare that these patents are not, you know, indigenous in South Africa. I think I will allow Dr. Tandanani Twele to talk about that. But as far as copyright and other, you know, designs and trademarks are concerned, we need to create. We're actually talking about this, how we're going to do it, because there are a lot of other steps that are related to this registration in order for them to be completely protected. For instance, we need to decide how they are going to get the community prior informed consent. As you know, the Ndebeles, I'm sure you've seen that the BMW actually used the Ndebele design in some of their cars, their interior BMWs. And we just want to make sure that the community also benefits for their cultural design being used, you know, in Europe. So that is not in place yet, and I believe that the IPLA Act will enable us to put these structures in place going forward. In terms of the benefit, once it is registered, then whoever comes, or when we see anybody in the international world using this, whatever it is, whether it's a design that is South African or a trademark or copyright cultural expression, we can actually do something about that. So there is a lot of work that still needs to be done in this area, just so that we are enabled to get our communities to actually benefit. There is also another area of structure that has been put in place, especially in Africa, that we are talking about also in WIPO, which relates to the benefit sharing mechanism, so that the community can share, and not only one person who probably was clever enough to run with an indigenous knowledge or a cultural expression that belongs to the community. So let me allow Tandanani to just talk about what we do already within the current Patent Act as it relates to patent registrations. Tandanani, you can clarify that one, because we think this is what we need to do with the other domains of IP as well. Tandanani, over to you.
Good day, Chair, and good day, members. I'll keep it short. And in the area of patents, whenever the invention derived from traditional knowledge or somehow the inventor benefited from the indigenous knowledge or traditional knowledge, we already have in place as a requirement before the patent can be granted that the inventor must declare, or the applicant must declare, whether the invention was derived from indigenous knowledge or traditional knowledge. If that's the case, of course, one must provide proof that they received they had an agreement with the community that developed that traditional knowledge, or that are the custodian of that knowledge. So that's what is already in place. But I have no doubt with maybe with when the patent bill maybe is stable, maybe it will strengthen this area. But I understand for now that's what we are doing when while IPLA as an act is not operational. I think that's all I wanted to say. Over to you.
Thank you very much. That seems to conclude presentations. Am I correct, Acting DG?
Yes, Chair, that's correct.
Okay. Now, honorable members, is there anything that, in your view, may have been left behind, such that one feels fundamentally that it has not been responded to, so that we can conclude? Members? Andre, you will guide me, those who may have shown interest. Yes, Andre?
Just no hands, Chair.
Okay. Andre, is there any other item remaining?
Chair, there's no any further items on the agenda. Is for you to conclude, Chair.
Okay. Members, noting that there's no further business, the meeting will now adjourn, and I will request that members take into account that we have a session at 2 o'clock. Thank you very much. The meeting is adjourned.
Thank you, Chair.
Thank you, Chair.
Thank you.
Recording stopped.